All right. Mr. Wagner, you're up.
Good morning, Your Honor. My name is Sean Wagner. May it please the court, Judge Northcutt and Kazam. I represent Clearwater Business Law, the petitioner in this case. This is a petition for writ of certiorari. We're asking this court.
We also have a third judge, Judge Rothstein. Joachim is also here.
Yes. Excuse me, Judge Rothstein. I've got my camera in front of my screen, so I can't see the whole screen. I'm sorry about that. We're asking the court to grant the petition for writ of certiorari, quash a discovery order requiring Clearwater Business Law to respond to a third-party subpoena to our law firm and produce documents in which we have claimed privilege and in which we have raised a motion for protective order. The motion for protective order was granted, and then it was ungranted when the trial court entered a reconsideration order. Neither order had any analysis, so we don't really know what the rationale was, but we had a protective order for a time, then we didn't, and now we're here. So normally we don't, I've never argued a petition for writ of certiorari oral arguments. Mr. Haas, counsel for the respondents, has asked for the oral argument. The basis for the request for oral argument is to, quote, correct misstatements in our reply. I don't believe there are any misstatements in our reply, and I'm not aware of what misstatements Mr. Haas intends to argue, so I'll have to hear it in real time like your honors. But I would like to tell you a little bit about the case. I would like to tell you why I think it's important and why I believe you will grant the petition for writ of certiorari. This case raises really three very important issues, and it touches upon a fourth. And those issues are the attorney-client privilege and the sanctity of the attorney-client privilege, the jurisdiction of this court, the power of this court to resolve cases on appeal, and the abuse of the privilege that all attorneys have to sign and issue subpoenas. I learned in law school, there was a time, I think, when attorneys couldn't issue their own subpoenas. They had to go to the clerk and get it. And now attorneys, for convenience sake, have the ability to do that. But this case presents a very clear instance where an attorney is abusing that privilege, and we're seeking certiorari relief. The fourth issue that really gets touched upon more tangentially, but it's also important.
Mr. Wagner, let me interrupt you,
Sure.
if I may. Let me see if I could focus a little bit of some of the issues that I think,
Sure.
for me, causes me a little bit of a concern. We're here on a cert petition.
Yes.
And in a cert petition, you basically have to make a showing that this is a clearly departure of any essential requirements of law. You also say that this case is really unique, and you go through that it's an extraordinary, to use your words, extraordinary situation that doesn't fit into the typical discovery pattern before the court. So doesn't, by virtue of you saying it, kind of undermine the issue that if there's a clear departure, what is it that it is departing from in this case? And when you answer that question, my follow-up would be, we're dealing with a partial final judgment that's now on appeal. That's not part of this. And what effect does this non-final order have on the other judgment? But let me focus first on the certiorari aspect of it. And I'm going to mute because I think I'm getting some feedback from my microphone.
Yes, Your Honor, thank you. So, the three reasons why the court will grant, I believe, certiorari in this case is that the request to our law firm is not relevant. It involves matters of privilege that have not been addressed by the court by way of an in-camera review, and quite frankly, it's addressed for an improper purpose, and it's being used for improper purpose. How that fits into the law of certiorari, which I think is more germane to your question, Judge Kazam, is this: to establish jurisdiction, we have to show that the matter will result in irreparable harm. We have shown that. And to establish right to relief, we have to show that there's been a departure from the essential requirements of the law. There is a clear fact pattern where there is both a departure from the essential requirements of the law and and jurisdiction and irreparable harm. And that is this: when a party is ordered, or a non-party is ordered, to produce discovery in which the party or non-party claims privilege, the trial court has an obligation to conduct an in-camera review before ruling on the privilege issue. Here, not only did we not get an in-camera review, we made a request at every step along the way. I know that there were multiple protective order motions and multiple times back and forth, but if you look at the record, clearly every time we were before the court asking for relief, we asked for an in-camera review and we asserted privilege, and the court just kind of ignored us and never did the in-camera review. That in and of itself is a
Mr.
basis.
Wagner?
Yes, ma'am.
Can I just get clarification of something? The privilege that you're asserting with respect to the documents, is that held by anybody other than the SPSF board?
It's held by, Your Honor, the Cobb Board, and we've referred to the two competing parties in this case.
Dispute. That's the dispute that's on appeal in the separate appeal, right?
Correct.
So if the Cobb Board is synonymous with the SPSF board, then you're correct, right?
No, I think it's backwards. And let me explain to you my theory on this. So our theory. So it's very simple. The declaratory judgment, which is on appeal right now, determined that the Holly Board, they're the respondents in this case, the Holly Board is the lawful board of directors of this not-for-profit corporation. One of the consequences of that judgment was that the partial final judgment that's on appeal also said, and nothing that the Cobb Board did back to June 17th of 2016 has any legal effect. It's void in ultra vires, and the case law is very clear that says void in ultra vires acts have no legal effect. So the record is also very clear that the individuals making up the Cobb Board retained Clearwater Business Law after June 17th of 2016. If they didn't have the authority to bind the corporation through the retainer agreement because the court voided that and said it's not valid, then the corporation didn't hire us. And if the corporation didn't hire us, we were never the corporation's lawyer. And if we were never the corporation's lawyer, then the corporation...
Mr. Wagner, but I think you're contradicting yourself. As I see this in what you've raised, you're claiming that your communication in representing SPSF is privileged and belongs to SPSF. The problem is that SPSF could never have been your client because of the finding of the partial final judgment. So it's circular. So how can you claim privilege? You do acknowledge that the privilege belonged to SPSF, but then you say that SPSF can't waive it because of the partial final judgment. And then sometimes you call yourself the Cobb Board's privilege. So all that is conflicting. Help me out with that.
Well, respectfully, Your Honor, I just think you've got our argument backwards. And so the Cobb Board does not have any connection to SPSF because the Cobb Board was declared to be not SPSF. The Cobb Board is a separate entity. We believe the Cobb Board we don't know what's going to happen with the appeal. The Cobb Board is not SPSF. The court declared that, and the court said nothing that the Cobb Board did has any legal effect. Therefore, if the Cobb Board is not SPSF, then SPSF can't waive the Cobb Board's privilege. I understand what you're saying because the references are different throughout the case, and that's partly because of the confusion of the way this all laid out. No, I want to be clear that the Cobb... Go ahead.
No, but I understand, Mr. Ryan. I'm just asking the question based on what you've alleged in the briefs. So I am not making this up. It's in your brief itself that you appear to be taking contrary views. That's my concern. And I want to give you the opportunity, because we're in oral argument, to explain that.
I understand. And I appreciate the opportunity. So I don't believe we're taking contrary views. I think it's confusing, and I acknowledge that. But at the end of the day, you've got two boards that are both claiming to be the rightful board of SPSF. One of those boards, the Cobb Board, was declared not to be the board of SPSF. Therefore, the privilege does not belong to SPSF because the Cobb Board is not SPSF. The privilege belongs to the individuals.
I understand that determination is currently on appeal before this court in another case.
Correct, but the assertion that the respondents make that they can waive our privilege, that they can waive the COB board's privilege, is entirely based on the declaratory judgment that's on appeal. The logic is this: the declaratory judgment said we're the true board of SBSF. You're claiming privilege on behalf of SBSF, therefore we can waive your privilege. It's the middle proposition that they're wrong on. We're not claiming privilege on behalf of SBSF. We're claiming privilege on behalf of the individuals that make up the COB board, who, by the way, lost the judgment.
That's the answer I was trying to get in first place.
Yeah.
Thank you.
Thank you.
Let me ask you a question then, Mr. Wagner, because you have that other judgment that's up on a separate appeal. Was there any type of bond filed in this case? Because what happens if the other appeal reverses the trial court's determination? Does that somehow the decision in this case? And where do we go from here? We're dealing with we're dealing with the cert petition here, and then we have a final judgment that's on appeal on a separate appeal. How does that work?
I'm sorry, I didn't mean to interrupt you. I understand with respect to the question of bond, we moved the day after the judgment came out, we filed a notice of appeal and we moved for an appellate stay. And we offered to post a supersedious bond, but the trial court denied the motion for a stay. So we're in a position.
It's not a money judgment, so there's no automatic stay that you would be entitled to.
That's correct. I believe that we did everything we could up until the point where we were essentially no longer able to represent our clients to get a stay, and we would have posted a supersedious bond because we wanted to maintain the status quo, mostly for the welfare of the animals. But I can't answer your question with we have posted a supersedious bond because we offered and we were not given the relief that would warrant a supersedious bond. But I believe if the case is reversed and it goes back down, the status quo will, at least legally, not physically, the status quo will be restored, and there will be no true and proper board, and that will be open for a retrial, and we'll be right back where we were. So the irreparable harm aspect comes here, that if you make us turn over these documents now, and then your colleagues reverse the declaratory judgment, you will have made us turn over documents on the assumption that Mr. Haas and his clients are the true board, and that assumption is not final because that assumption is on appeal. That's where the irreparable harm comes in.
Two aspects of that I gather that is your concern. One, you can't put that cat back in the bag. And two,
Yes, sir.
Your attorney-client relationship is with the individuals who were attempting to constitute the board, the COB client, the COB people, and not necessarily the corporate entity, but the people who were claiming to be the board of the sanctuary.
That's correct. And with respect to the relationship between our law firm,
so regardless of how from that view, regardless of how the appeal turns out, you would still claim the privilege because your firm was advising or an attorney-client relationship with those individuals who claim to be the board.
yes, sir. There's only two ways this case could shake out in light of the appeal. The judgment could be affirmed, which means that the court said definitively the COB board was never the board of directors for the corporation, and nothing the COB board did, including hire Clearwater Business Law, had any legal effect. That would mean the privilege belongs to the COB board and the individuals on the COB board. The other possibility would be that the court reverses, sends it back down for a declaratory action trial, and the COB board is then declared the true and rightful board of the corporation, which would mean the privilege belongs to the corporation, but we control the privilege. Either way, this is still a live issue, and if the cert petition is not granted now, there will be irreparable harm because the material that we're trying to assert privilege on will have already been turned over. The cat would be in fact out of the bag, and we wouldn't have had that in-camera review.
Did you file a privilege log?
We offered to the court several times. What we did was we took hundreds and hundreds and hundreds of pages and we redacted them. redacted out the privileged material, because it's not all privileged, right? There's some items in there that just aren't privileged. So we redacted out the privileged materials and we offered it to the court for an in-camera review. The reason we didn't file a privilege log is because the law is clear. You don't have to file a privilege log until the court argues that the items are otherwise discoverable. Because we were granted a protective order for a time and then ungranted the protective order, that when the protective order was ungranted, I say ungranted, what technically happened is the motion for reconsideration was granted, but because we lost the protection from the protective order, that's when the privilege issue became a live issue, and that's when we offered the court to submit the redacted version for a in-camera review, and the court just didn't even consider that in its decision. So I don't believe that we waived any issue by not formally filing a privilege log based on the fact that the protective order was there and the items weren't otherwise discoverable until we offered up the redacted version.
I guess I'm having a hard time understanding that, Mr. Wagner. How can you not know who has the privilege and why? And Judge Northcott asked this question that I was ready to ask, but I don't see any privilege along here. If you believe that you have the privilege, why not do a privilege log?
So two things. The first question was, how can you not know who represents a corporation? Unfortunately, so I haven't been a business litigator for that long. I spent most of my career as a criminal trial attorney and a criminal appellate attorney. So one of the things that I learned very quickly when I got involved in these disputes over corporations is the battle lines are never clear. They shift. When you've got two individuals and they're both claiming to be the governing body of a corporation and you go to the courts clearly have declaratory jurisdiction to make this decision. The Declaratory Judgment Act contemplates that the courts are going to step in and say, you're the board and you're not the board. There can only be one board. So in that circumstance, and that's the case you have here, you have two separate boards, both claiming to be the true board and asking the court for a declaratory judgment. When you're litigating that issue, and by the way, this case survived summary judgment, so it's not like it was never an open issue as to who was the board. Let me
interject, Mr. Wagner.
Yeah.
I don't frankly recall whether you asked to reserve rebuttal time, but you're down to about 4 minutes. So
I'd like to reserve, Your Honors, but I would like to finish answering the question. I'll reserve the balance of my time.
Right.
Judge Kazam, the other issue is this. The law is pretty clear that you only have to file a privilege log when when the items are otherwise discoverable. And what that means is if there's a question as to relevancy, if there's a question as to whether there's going to be a protective order granted, then the items aren't otherwise discoverable and you don't have to file a privilege log. We had a protective order between April of 2023 and July of 2023. So the items weren't discoverable until we lost the protective order. And at that point, we offered up the items, not a privilege log. We offered up the items in redacted form. And there's plenty of case law out there. I don't think it's the privilege log. I think it's offering up the redacted items so that everybody can see what privilege you're claiming for in-camera review. And we did that, which I think preserves the issue. And I'll reserve the balance of my time, Your Honor.
Okay. Thank you, Mr. Wagner. Mr. Haas?
Thank you.
If I may, Mr. Haas, the question that I asked Mr. Wagner, what's the effect of this cert petition on the pending appeal from the partial final judgment?
Well, I don't know who the panel is going to be, but and I will tell the court that in the appeal, the appellants have in their brief stated that they are not challenging the finding of the trial court that there are no members of the corporation. And if you understand,
did you say that they made that argument in their appeal or in the cert petition?
What I'm saying is because Judge Kuzam's asking about the related appeal.
Yeah.
What I'm saying is in the related appeal, the appellants have essentially, they claim they haven't conceded it, but yet they admit that they haven't challenged it. So I don't know what the difference is. I really don't. But they've said they're not challenging the finding of the trial court that's in that final judgment that you have, that 6-page final judgment, that there are no members of the corporation. Well, understand in a not-for-profit corporation, If you have no members, because there are both
And
non-membership and membership entities.
Mr. Haas, let me interrupt you. I guess my main question is more procedural, that if the final partial judgment is reversed by this court, does that moot this case? And this is what I'm trying to find out.
I don't think it does. I don't think
Okay.
it does, Your Honor. The short answer, I don't believe it does. So let me, if I may, and again, may it please the court, Lee Hawes representing the respondents.
And I know we're peppering you with questions and so forth and so on, but let me tell you what a concern I have is that you have the COB members, COB board, whoever they are, hire an attorney and they engage in communications, which, you know, at least superficially or to all intents and purposes, those are privileged. And then you have an after the fact determination that they weren't the board, and suddenly those communications become unprivileged. I have some concern about that.
Well, the
I mean,
law
it's
is
not
clear.
like, for instance, you know, you have a third party in the room, and so you know those communications are not privileged. This is an after the fact determination of a status that suddenly changes the privilege calculation.
Well, I mean, as I've cited in my response, the law is clear. First of all, one of the misstatements in the reply brief is this notion that the privilege is with the Cobb O'Donnell Dillard board. And that's wrong. To Judge Yoakum's question, the law is clear. The privilege belongs to the corporation. The board of directors is not a legal entity. Under the statute, under section 617.01401, subparagraph 2, the definitional section of the statute, it says that the board of directors is merely a group of persons vested with the management of the affairs of the corporation. So
and
that
group of persons engaged in attorney.
Well, except here's the issue. Again, one of the significant cases I cited is Tale of the Pup Inc. versus Webb, 528 Southern 2nd 506. That's a second DCA decision. That clearly says that corporate power, including the power to waive the privilege that belongs to the corporation, can be waived by the board. And that applies to a successor board. So in the case, there is this notion that you can have a board of directors that does certain things, and then there is a lawfully elected subsequent board that comes along and says, we're waiving the privilege for the corporation, even as it relates to the prior board. They have the power to do that. The distinction, I'm sorry.
If I may, Mr. I guess what it boils down to, when somebody argues privilege, who is the client? This is what to instill everything, who is the client? If Mr. Wagner represented the individuals, then he's making the argument that privilege applies to them. But if the client is the corporation, then you're correct. The privilege doesn't belong to them. So I guess the question for us, who is the client in this case?
Well, here is the answer. And here are some questions that this court, in the 2.5 minutes that Mr. Wagner has left on rebuttal, should ask. To the extent that Mr. Wagner, that the petitioner, is now trying to disavow that it represented the corporation and was only representing the individuals by virtue of the trial court's judgment handed down on June 13, 2022. So basically, you know, put aside the fact that they have represented before multiple trial courts that they represent the corporation. Okay? Let's put all that aside for the moment. And the fact is that on June 13th, 2022, the trial court declares, no, you don't represent the corporation because Mr. Hawes is the one who's representing the corporation through its only true board of directors. Assume that's true. Here's the problem. How does the petitioner explain that the day after that judgment was entered, after it received that judgment, why did it direct Ms. Cobb to take $50,000 out of the corporation's bank account to put into their trust account? If you don't represent the corporation, why are you converting its assets? Secondly, question to be asked of Mr. Wagner, how does the petitioner explain the June 23rd, 2022 letter, 10 days after the judgment, which is in Respondents Appendix 8, page 7. It's a letter written to whom it may concern. It was sent to multiple banks and other financial institutions. And it claims to represent the de facto board of directors of the corporation. Doesn't claim to represent the individuals. And then tells them, essentially, freeze the corporation's assets. So you can't have your cake and eat it too. You can't say, oh, I never represented the corporation. I never acted like I represented the corporation, when you clearly claim to represent the corporation in multiple cases. In fact, boasted to the trial judges in this case that, oh, I'm really the one representing the corporation because I'm getting paid out of the corporation's bank account. I mean, again, part of the issue here is if he wants to say he was really retained by the individuals, then why has he taken tens of thousands of dollars out of the corporation's bank account to represent individuals if it's declared he had no right to claim to represent them as corporation? I mean, it is a circular argument that he's been engaging in, because you can't say, oh, I never represented the corporation, but I had the corporation, I sent my bills to the corporation, and I had the corporation pay my bills for these individuals who are antithetical to the corporation.
Mr. Haas, is that a question that's appropriately raised in the confines of this case, or is that more properly raised in a separate action? Obviously, with regard to the 50,000, that I think is the subject of the contempt motion, and the 50,000's been, I think, put in escrow. But to the extent there are these other claims, are they properly raised in the underlying case?
Yes,
Or
Your
should there
Honor.
be a-
Yes, Your Honor. As
Okay.
I pointed out in my response, the trial court, in his order, Judge Myers specifically said two things. Number one, Mr. Mongeluzzi, you give Mr. Hawes that $50,000 immediately. You get it into his trust account. And then he said, we need to conduct a full-blown evidentiary hearing on these other issues. Because again, part of the argument we were saying is, Judge, you entered a judgment, but these people aren't complying with it because they're refusing to give back the physical property that belongs to the corporation. They're refusing to give its assets back to the lawful board of directors. So it's not like the judgment's self-executing. We're having to go, we still don't have, as I pointed out in my response, to this day, these people that we sued have refused to turn over information, documents that belong to the corporation. They've never surrendered the bank account records to us. They haven't surrendered the social media passwords. In fact, they were maintaining a bogus separate website in the name of the corporation that was collecting donations through PayPal. So the court has continuing jurisdiction to enforce its judgment. And the citation that was made in
Mr. Haas, I don't understand how any of that is relevant to the cert petition on the privilege.
because it goes to the issue of if you look at the list of documents we asked for, and by the way, to correct something that Mr. Wagner says, what the court needs to be aware of is that initially, when I presented a subpoena, under Rule 1.351, normally it's just the party that gets to object. Then you serve the subpoena, then the non-party can object, okay? But that's not what happened. In the present case, the party didn't actually object, the non-party objected, and the court overruled that objection and initially said, these records are producible. Then they basically go, and they're the ones who ask for rehearing and get the judge to reverse himself. I then do a reconsideration saying, wait a minute, judge, over here you said we were entitled to it. Now you're saying we're not. I'm confused. And he goes, oh yeah, you're right. You are entitled to this stuff. So the record's clear. We initially had the right to get those documents. The documents are relevant to this case because they relate to the ongoing jurisdiction of the court to enforce the final judgment, which is to put the board in control of the corporate assets. That's part of being a board of directors, is exercising control over the assets of the entity that you're the board of. You have a fiduciary duty, in fact, to preserve the assets. So I hope that answers your question, Judge.
Assuming there's some possibility of a privilege or privileged communications between the Cobb board members and Mr. Wagner's firm, are you suggesting that none of what you have subpoenaed would fall within that that privilege?
None
Or
of it.
Might it be the case that we need the circuit judge to look at the material to make that determination?
Well, I will say this. I guess in some obscure way, it's remotely theoretically possible, but practically speaking, no. Because understand that Mr. Wagner's firm consistently represented to every court that would listen that they were the true counsel for Suncoast Primate. They basically almost said, oh, we're really only representing Suncoast Primate in a board. We're not really representing these individuals. So the notion that there is somehow a privileged communication between somebody at Clearwater Business Law and an individual defendant that is related to that individual defendant, I suppose it's theoretically possible. But for instance, they're also claiming membership status derivatively on behalf of the corporation in a counterclaim. So they're saying they're acting on behalf of the corporation in derivative. They're also sending all their billing to the corporation. The corporation is paying their billing out of the trust, out of the corporate accounts.
Well, if someone brings a derivative action against the corporation, are you suggesting that the corporation can turn around and obtain all the communications between that shareholder and the attorney because they're theoretically representing the corporation?
Not in the ordinary case.
Well, not in
the ordinary case, but the reason being is remember again, these people, part of their affirmative defense was, and part of the argument of petitioner to every judge that would listen is, we're really the lawyers for Suncoast Primate. And in fact, if you look at the Respondents Appendix 12, and you look at the retainer agreements that are attached, and you look at the retainer agreements, one is dated July 28, 2016, the other one's dated July 26, 2016. And they claim that they're representing the corporation and these individuals, and every one of them is signing individually and on behalf of the corporation. And then they turn around and file the derivative claim saying, oh, my client board, they're really just interlopers. And they're really the true representatives of the corporation. So I would agree with you, Judge, in the ordinary derivative action, and I've brought a few myself, no. That privilege that I have with my client in the derivative action is inviolate. But that's not this fact pattern. So let me, if I could, just, again, Judge Kuzam, you brought the point up, and I just simply want to emphasize again, they have a high burden to show a departure from the essential requirements of the law that results in material injury that cannot be corrected on appeal. And the question really is, what is the irreparable harm in giving the retainer agreements that they claim to have entered into with the corporation? What is the harm in producing the billing records to the corporation that they claim to have billed to the corporation? What is the harm in producing all of the checks paid by the corporation to the law firm? Where is the harm in that? And understand, if you look at the subpoena, that's what I asked for. Give me the retainer agreements. Give me the billing records. Give me the proofs of the records of payments as to all of these different lawsuits that you claim to be representing the corporation in. That's what I asked for. I didn't say, oh, I want your correspondence between you and Job Cobb as an individual who's sitting in Sumter Correctional right now. I didn't ask for the individual communications between you and your individual client, Sandra Dillard, or between you and your individual client, Charles O'Donnell. I didn't ask for that. If you read the subpoena, it's not there. I asked for stuff that related to the corporation that I've been declared to be the corporate counsel for, because I represent the one and only true board of directors.
Which then begs the question, Mr. Haas, that if there's a determination on appeal reversing that finding.
I'm sorry?
I said, if the separate appeal reverses the trial court's finding, if we pursue this, if let's just say we agree with you, we deny his cert petition, you get all the records, and suddenly now in the appeal, it reverses itself. Isn't that kind of cat out of the bag? You've already received all this information. How does that, and I guess my concern, how does the other appeal relate to here?
To your question, Your Honor, then the most prudent thing this court could do, I'm going to speak against my own interest. The most prudent thing this court could do would be to stay its decision and let the appeal get resolved. Let the other panel determine that I am, in fact, the proper corporate counsel for the proper board of directors. And then the day after the second district hands down its decision in that other case, this court denies certiorari. That would be my answer, Your Honor.
Thank you, Mr. Haas.
And I will, again, I will tell the court, remember, there was a 6-day trial. So the question, this is not like a summary judgment where the de novo standard review is going to apply, right? This is going to require the concept of substantial competent evidence for the court's findings and an abuse of discretion in interpretation of that evidence. Well, again, you have the appellant in the other case who has already said it is not challenging the finding of the trial court that there were no members of the corporation. And all you have to do, it's not rocket science. It's simple, basic corporate law. If there is no membership, then there's nobody to elect a competing board of directors. In
Mr.
which
Haas,
case,
you need to wind up because you're at the end of your 20 minutes.
yes, Your Honor. If there's no competing board of directors, then the judgment of the trial court cannot be reversed because there's literally nobody to stand up and say, I'm the real board, as opposed to the board that I've been representing. Thank you.
Thank you. Mr. Wagner, the rebut. As Mr. Haas pointed out, you have about 2.5 minutes.
Yes, sir. Your Honor,
Actually, Mr. Wagner, I've got a question that's really concerning me based on what Mr. Haas just said. So did you waive anything by claiming so many times that you represented the corporation?
Your Honor, this is a red herring. What happens when you are in trial level litigation and you're both claiming to be the board of directors for a corporation, as you say, we're the board of directors for the corporation. We're not the ones that ever said we're not the board. You know who said we're not the board? Judge Myers said we're not the board when he entered the declaratory judgment. our position is Mr. Haas's entire argument, the respondent's entire argument as to why they're entitled to these records is that they won the declaratory judgment. The declaratory judgment giveth, and the declaratory judgment taketh away. And one of the things that it gaveth was it gave them, at this point, the status as the board of directors. What it took away is their ability to come after us and say, we're the board of directors and we own your privilege. The privilege doesn't belong to the corporation. The privilege belongs to the client. If the client happens to be a corporation, yeah.
Mr. Rice, you're still not answering my question.
Okay.
My question is, did you waive that by claiming this many times? That's all that I'm concerned
We did
with.
not waive that at all. We did not waive it. When the declaratory judgment came out, we acknowledged what the declaratory judgment said.
Okay, because if Mr. Haas is saying that after the court made that determination, you went ahead and you've asked for the money, you've done all this is in the record. Why isn't that? I mean, your brief, you say all that belongs to the corporation. That's why I'm having a hard time following. You're contradicting yourself. And I want to give you the opportunity now to clarify that while we're in oral arguments.
And you know, Mr. Haas has his own view of the record. We never said, there's no evidence that we went to anybody. First of all, it's my firm, it's not me. There's no evidence that our firm went to anybody and asked anybody for money. Mr. Haas just makes this stuff up. It's not in the record. Go back and read the record. What happened, and what is very clear, is that the day after the declaratory judgment came out, our firm filed a notice of appeal. The day after the declaratory judgment came out, a check came into our firm. That doesn't mean that we waived the ability to say we're not the corporation. What we're doing is we're filing a notice of appeal and moving to stay the judgment because the case is live and it's on appeal.
You're at the end of your time, Mr. Wagner. Thank you both very much. In order to depart our virtual courtroom, you click the leave button in the lower right-hand corner of your Zoom screen, and you'll disappear.
Thank you, Your Honor.
Thank you both very much. Okay, the court will be in recess for 10 minutes.